I was staring out my kitchen window at the worst blizzard Montana had seen in 15 years when someone started hammering on my front door like they were trying to break through solid oak with their bare fists. The snow had been falling for 36 hours straight, transforming my property outside Billings into a white wasteland. I had power thanks to my generator, plenty of firewood, and enough food to last weeks. What I did not have was patience for whoever was assaulting my door at 7 in the morning during a state of emergency. I wrapped my flannel robe tighter and trudged through my living room, already irritated before I even saw who was responsible for the racket. Through the frosted glass beside my door, I could make out a figure bundled in what looked like every winter coat ever manufactured. "Hello," I called out, not opening the door yet. "Open up right now. This is an emergency." The voice was shrill, entitled, and unmistakably female. I cracked the door open, and a blast of Arctic air hit me square in the face. Standing on my porch was a woman in her mid-50s, her face red from either the cold or rage, possibly both. Behind her, I could see a white SUV stuck in a snowdrift about 50 yards down my driveway. "Can I help you?" I asked, keeping my tone neutral. "I'm Patricia Winters, president of the Meadowbrook Hills Homeowners Association. I need to use your phone immediately. My cell is dead and I've been stuck out here for over an hour trying to reach your property." "You drove through a blizzard during a state of emergency to reach my property." I was genuinely baffled. "Why?" "That's HOA business, which we will discuss after I make my calls. Now let me in before I freeze to death." Something about her tone made every rebellious bone in my body stiffen. I was Lucas Warner, and I had owned this 150-acre property for 8 years. I had spent those years enjoying the solitude, working remotely as a software consultant, and appreciating the fact that I did not have to deal with people like Patricia Winters. But I was not a monster. The woman looked half frozen, and I could not in good conscience leave her out there. "Come in," I said, stepping aside. She pushed past me without so much as a thank you, leaving a trail of snow across my hardwood floors. She looked around my living room with barely concealed disdain, taking in my comfortable but decidedly modest furnishings. "Phone," she demanded. I pointed to the landline on the side table. "Help yourself." While she made her call, I went to start a pot of coffee. I had a feeling I was going to need it. Through the doorway, I could hear her barking orders to someone about tow trucks and emergency road clearing. When she finally hung up, she marched into my kitchen like she owned the place. "Coffee will be ready in a few minutes," I said. "While we wait, maybe you can explain what HOA business was so urgent it couldn't wait until after the storm." Patricia settled herself at my kitchen table without being invited. "Mr. Warner, is it?" "I'm here because you have been in violation of multiple HOA covenants and bylaws for quite some time now." I leaned against my counter and crossed my arms. "That's impossible, considering I'm not part of any HOA. Everyone in Meadowbrook Hills is part of the HOA. It's not optional." "I don't live in Meadowbrook Hills." Her expression shifted to something smug and superior. "Actually, you do. The boundaries were redrawn 18 months ago when we incorporated another 200 acres into our development. Your property falls within our jurisdiction now." I felt ice settle in my stomach that had nothing to do with the temperature. "Excuse me," the county approved our expansion. "Your property is now part of Meadowbrook Hills, which means you're subject to all our rules and regulations. You should have received notification." "I received no such thing." She waved a dismissive hand. "That's hardly my problem. Ignorance of the law is no excuse. You owe approximately $4,000 in back dues, and you're currently in violation of at least 7 separate covenants." The coffee maker beeped. I poured 2 cups with hands that were remarkably steady considering I was fighting the urge to throw this woman back out into the snow. I set 1 cup in front of her and took a long drink of my own. "What violations?" I asked. Patricia pulled out a tablet from her enormous purse. Apparently, it still had battery life. "Your fence is the wrong color. Your outbuildings are not architecturally consistent with approved styles. You have visible firewood storage. Your driveway exceeds the maximum allowed length without proper landscaping barriers. You have more than the permitted number of vehicles on your property. Your house needs repainting in an approved color scheme, and you have livestock, which is absolutely forbidden." "Livestock? You mean my 2 horses? Horses are livestock." I set my coffee cup down carefully. "Lady, I don't know what kind of scam you're running, but you need to leave my property as soon as your tow truck arrives." "This is not a scam, Mr. Warner. This is the law. You have 30 days to comply with all violations and pay your back dues, or we will be forced to place a lien on your property. Get out." "I beg your pardon," I said. "Get out. You can wait for your tow truck in your car." Patricia stood up, her face flushing even redder. "You are making a very serious mistake. The HOA has significant legal power, Mr. Warner. We can make your life extremely difficult. And you've just threatened me in my own home. Leave. Now." She gathered her things with sharp, angry movements. "You'll be hearing from our attorney." "I look forward to it." I watched her stomp back out into the blizzard, pulling the door shut behind her with perhaps more force than necessary. Through my window, I watched her struggle through the snow back to her stuck SUV. Part of me felt guilty for not letting her wait inside, but mostly I felt angry and violated. No notification. No discussion. Just demands and threats. I spent the rest of the morning trying to work, but concentration was impossible. Finally, I gave up and called my neighbor, Tom Henderson, who lived about 2 miles down the road. Tom had been in this area for 30 years and knew everything about local politics and land issues. "Lucas, how you holding up in this mess?" Tom answered. "I've been better." "Tom, what do you know about Meadowbrook Hills expanding?" There was a long pause. "Ah, hell, they got to you too. There's been a fight brewing for about 2 years now. This development company, Mountain Vista Properties, bought up a bunch of land adjacent to their original development. They've been trying to incorporate surrounding properties into their HOA boundaries to increase their dues, revenue, and property values. Can they do that legally? That's the question everyone's been asking. They claim they got county approval, but a lot of folks say the process was shady as hell. The county commissioner who approved it suddenly could afford a very nice new boat right after the decision came through, if you catch my drift. I caught his drift. What have people been doing about it? Most of the affected properties are vacation cabins or undeveloped land. Owners live out of state and just end up paying rather than fighting. But there's a group that's hired a lawyer. You should talk to Sarah Mitchell. She's been leading the resistance, so to speak. Tom gave me Sarah's number and I called her as soon as we hung up. She answered on the 3rd ring, sounding exhausted. "Sarah Mitchell." I explained who I was and what had just happened. She listened quietly, then let out a long sigh. "Welcome to the nightmare, Lucas. How much do you know about your property's history?" "I bought it 8 years ago from the Jacobson family estate. It had been in their family for 3 generations. I've got a clean title survey, everything." "You happen to know anything about easements on your property?" "Easements?" "There's an old access road that runs through the northwestern corner. It was part of the original homestead access before the county road system was developed." "Why?" "Because that might be exactly what we need. Can you send me a copy of your title and survey documents?" "Sure, but can you tell me what you're thinking?" "Not yet. I don't want to get your hopes up. But if what I suspect is true, Patricia Winters and her HOA are going to have much bigger problems than trying to extort dues from you. The storm continued for another 2 days. I spent that time digging through my property records, scanning documents, and sending everything to Sarah. I also did my own research on Montana property law, easement rights, and HOA regulations. What I learned was both encouraging and infuriating. HOAs in Montana did have significant power, but their authority was not unlimited. They could not simply absorb private property into their jurisdiction without proper notification and due process. The fact that I had received no official notice was a major problem for them. More interesting was what I learned about easements. The old access road that ran through my property was not just some forgotten historical footnote. It was a permanent, recorded easement that predated not just my ownership, but the entire modern development of the area. That easement provided access from the county road through my property and onward to what was now the Meadowbrook Hills development. On the 4th day after Patricia's visit, my phone rang. It was Sarah. "Lucas, are you sitting down?" "Should I be?" "Probably. I've been going through your documents and doing some research. That easement on your property, Meadowbrook Hills is using it. The entire development's main access road is built on that easement." I sat down. "What does that mean exactly?" "It means they are using your property for access. The easement gives them the right to pass through, but here's the thing. The easement terms specify that it's for access to agricultural lands. Meadowbrook Hills is not agricultural. They've been using an easement they technically have no right to use, and they've done it without ever notifying you or seeking permission to change the easement terms. How is that possible? Because no one bothered to check the old records. The easement dates back to 1892. The development company either did not know about it or assumed no one would ever call them on it. Either way, you have significant legal leverage here. What kind of leverage? The kind where you could potentially block their access if they don't play nice. That road is the only way in and out of about half their development. They have no alternative access without either buying land at enormous cost or building through protected wetlands, which they'll never get permitted. I felt a slow smile spreading across my face. So when Patricia threatened to put a lien on my property, she had no idea she was threatening someone who could shut down half her development. "Lucas, you need to get an attorney immediately. This is going to get ugly." She recommended a property lawyer named David Chen, who had experience with easement disputes. I called him that afternoon, and we set up a meeting for the following week once the roads were clear. In the meantime, I received my official notification from the Meadowbrook Hills HOA. It came via certified mail, delivered by a very cold and annoyed postal worker who had to chain up his truck just to reach my mailbox. The document was impressive in its officious pomposity. It informed me that my property had been incorporated into the Meadowbrook Hills Community Development District 18 months prior, per County Resolution 2023-447. As a property owner within the district, I was subject to all covenants, conditions, and restrictions. I had 30 days to remit back dues of $4,200 and submit plans for correcting all violations, or face enforcement action including liens and potential foreclosure. There was a phone number for questions. I called it. "Meadowbrook Hills HOA. This is Deborah speaking." "This is Lucas Warner. I just received your notification letter and I have questions." "One moment, let me pull up your file," I heard typing. "Ah, yes, Mr. Warner, I see you spoke with our president, Patricia Winters, last week. She broke into my house during a blizzard and threatened me. I'm sure Mrs. Winters was simply trying to inform you of your obligations. Now, how can I help you today? How was I incorporated into your HOA without notification? All legal notifications were properly filed with the county. Property owners are responsible for staying informed of county actions affecting their land. That's not how it works, and you know it. You're required to provide direct notification to affected property owners. Her voice went cold. Mr. Warner, if you have legal concerns, you're welcome to consult an attorney. However, I suggest you focus on compliance rather than litigation. The HOA has substantial resources and an excellent legal team. Is that a threat? It's a fact. Will you be remitting payment today? No. Then you'll be receiving notice of our enforcement actions shortly. Have a good day, Mr. Warner. She hung up. I sat there looking at my phone, anger building in my chest. These people were used to steamrolling anyone who got in their way. They thought money and lawyers could solve any problem. They had no idea what was coming. My meeting with David Chen took place in his office in downtown Billings. He was a sharp-eyed man in his 40s, with the calm demeanor of someone who had seen every dirty trick in the book and was not impressed by any of them. Mr. Warner, I've reviewed the documents you sent. This is quite a situation. That's one way to put it. Before we discuss strategy, I need to understand your goals. Are you looking to simply avoid the HOA obligations, or do you want to pursue this more aggressively? What do you mean by more aggressively? David leaned back in his chair. Your easement situation gives you significant leverage. We could potentially seek damages for their unauthorized use, force renegotiation of access terms, or even seek to block their use of the easement entirely until proper compensation and permissions are established. Would that hold up in court? Almost certainly. The easement terms are clear. Agricultural access only. A residential development is absolutely not an agricultural use. They've been trespassing, essentially, for the entire life of their development. How long has the development existed? 5 years for the original phase. 3 years for the expansion that now supposedly includes your property. So they've been illegally using my easement for up to 5 years. Correct. Now, if we pursue this aggressively, they will fight back hard. HOAs can be vicious opponents, especially ones with deep pockets. This will get expensive and time-consuming. I thought about Patricia Winters in my kitchen, making demands and threats. I thought about the smug voice of Deborah on the phone, treating me like I was an inconvenience to be crushed. I want to fight, I said, not just to avoid their rules. I want them to understand they cannot do this to people. David smiled. Then, let's make them understand. The first step was sending a cease and desist letter regarding my alleged HOA membership. David drafted a comprehensive document pointing out that I had never received proper notification, had never signed any agreement to join the HOA, and was challenging the legality of the county resolution that supposedly incorporated my property. The second step was more interesting. We sent a separate letter, this one informing the Meadowbrook Hills development that they were in violation of easement terms and demanding immediate cessation of use, pending negotiation of proper access rights. We sent both letters on a Wednesday. By Friday afternoon, my phone was ringing off the hook. I did not answer. David had advised me to direct all communication through him, and I was happy to comply. Let them stew. On Monday, I got a visit. Not from Patricia this time, but from a man in an expensive suit who introduced himself as Marcus Holloway, attorney for Meadowbrook Hills HOA. Mr. Warner, I apologize for arriving unannounced, but this situation requires immediate attention. Then you should make an appointment with my attorney, David Chen. I'm hoping we can resolve this man-to-man without letting the lawyers complicate things. I almost laughed. You're a lawyer. I'm here as a representative of the HOA trying to find a reasonable solution. The reasonable solution is for your client to stop trying to steal my property and stop using my easement without permission. Marcus's friendly expression slipped a bit. Mr. Warner, I think there's been a misunderstanding. The HOA has no intention of stealing anything. We simply need to bring all properties within our district into compliance with our standards. I'm not in your district. The county says you are. The county made a decision without properly notifying affected property owners. That's not legal and you know it. That's a matter of interpretation. No, it's a matter of law, and while we're discussing law, let's talk about your development's use of my easement. His expression went carefully neutral. What about it? You're using it illegally. The easement is for agricultural access only. I want your traffic off my property immediately. That's absurd. That road has been in use for years. We have established access rights. You have nothing. Check your title work. That easement has specific terms and you're violating them. If your development's engineers and attorneys failed to catch that during planning, that's your problem, not mine. Marcus stood up. Mr. Warner, I came here hoping to avoid a legal battle, but if you insist on being unreasonable, the HOA is prepared to pursue every available remedy, including trying to force me into an HOA I never agreed to join, including trying to extort thousands in fake dues, including threatening liens and foreclosure. Yeah, I'm the unreasonable one. You'll be hearing from us through official channels. I look forward to it. After he left, I called David and filled him in on the conversation. Good, he said. You didn't commit to anything, didn't make any statements they can use against you. Now they know we're serious. Next comes the real pressure. He was right. Over the next week, I received letters from the HOA's legal team, from the development company's attorneys, and even from a county attorney suggesting I was being unnecessarily difficult about what should be a simple administrative matter. David responded to each one methodically, laying out the facts and the law. Meanwhile, he filed a lawsuit on my behalf seeking a declaratory judgment that I was not part of the HOA and an injunction against the development's use of my easement. That's when things got interesting. 2 days after our lawsuit was filed, I got a call from a reporter named Jennifer Schultz with the Billings Gazette. Mr. Warner, I'm doing a story on the Meadowbrook Hills HOA expansion controversy. Would you be willing to speak with me? What controversy? You're not the only property owner fighting this. There are at least a dozen others who are challenging the HOA's attempt to absorb their properties, and there are questions about how the county approved the expansion in the first place. What kind of questions? The kind that involve the county commissioner, who approved the resolution, suddenly having access to funds he didn't have before. The kind that involve the development company's CEO being the commissioner's brother-in-law. That kind of question. I told her I would talk to David and get back to her. When I called him, he was quiet for a long moment. This could help us, he finally said. Public pressure can be very effective, but once you go public, you're committed. The HOA will come after you even harder to make an example of you. They're already coming after me. Fair point. If you want to talk to her, I'll sit in on the interview to make sure you don't say anything that could hurt our case. The interview took place at my property the following week. Jennifer was a thorough professional, asking detailed questions and taking extensive notes. She was particularly interested in the easement issue. So if I understand correctly, the development's main access road is built on your property? On an easement through my property, yes. And they never asked your permission, never even notified me it existed until I checked my own property records. What happens if you block their access? David interjected. We're not threatening to block anything. We're simply asking that the development comply with the law and negotiate proper terms for their use of Mr. Warner's property. But theoretically, you could block their access. The easement has specific terms, David said carefully. If those terms are being violated, the property owner has rights to enforce those terms. Jennifer smiled. She knew a story when she heard one. The article ran the following Sunday, front page of the local section. The headline read, HOA expansion fight reveals questionable county approval and property rights violations. It was thorough, well-researched, and absolutely damning. Jennifer had tracked down multiple property owners fighting the HOA. She had obtained records showing the suspicious timeline of the county commissioner's approval and his sudden financial windfall. And she had included a detailed explanation of my easement situation, complete with a map showing how the development's access road ran through my property. The reaction was immediate and explosive. By Monday morning, the county commissioner, Rick Stevens, had issued a statement saying he would recuse himself from any future matters involving Meadowbrook Hills, and that he welcomed an independent review of the approval process. That sounded noble until you realized it was pure damage control. The development company issued their own statement claiming all approvals were obtained legally and properly, and characterizing the property owner's resistance as a small group of malcontents trying to avoid their civic responsibilities. The HOA, through Patricia Winters, gave a quote that made my blood boil. Mr. Warner and others like him want all the benefits of living near a well-maintained, high-quality community without contributing their fair share. It's selfish and short-sighted. I was not living near their community. They had tried to absorb my property into their community without my knowledge or consent. But facts did not seem to matter much to Patricia. The article did have one positive effect. I started getting calls from other property owners in similar situations. We formed an informal alliance, sharing information and coordinating our legal strategies. Most did not have the leverage I had with my easement, but together we could make a stronger case that the county's approval process had been fatally flawed. In March, 2 months after Patricia's visit during the blizzard, we had our first court hearing. It was just a preliminary matter, arguments over whether my lawsuit should proceed and whether the injunction against the development's use of my easement should be granted. The courtroom was packed. Besides the lawyers and parties directly involved, there were at least 30 other people present, most of them property owners fighting similar battles. Jennifer Schultz was there taking notes. And sitting in the front row on the HOA's side was Patricia Winters, looking like she wanted to set me on fire with her mind. Judge Catherine Morrison presided. She was known as a no-nonsense judge who did not tolerate games from either side. The HOA's attorney, a slick operator named Gerald Hayes, argued first. Your Honor, the plaintiff's claims are without merit. The county properly approved the expansion of the Meadowbrook Hills Community Development District. All legal requirements were met. Mr. Warner's property falls within the new boundaries, making him subject to the HOA's authority. His refusal to comply with legal obligations is not grounds for a lawsuit. What about the notification issue? Judge Morrison asked. The law requires filing with the county, Your Honor. It doesn't mandate individual notification to every property owner. Mr. Chen, your response. David stood. Your Honor, while it's true the county approval was filed publicly, there's also a requirement for reasonable notification to affected parties when their property rights are being substantially altered. Mr. Warner received no notification whatsoever until the HOA sent someone to his house demanding back dues. That's not due process. The notification issue aside, Let's discuss this easement situation. Mr. Hayes, was your client aware of the easement terms when they built their access road? Gerald Hayes looked uncomfortable for the first time. Your Honor, the easement is a historical artifact. It's been in effective continuous use for modern purposes for years. That's not what I asked. Was your client aware of the specific terms of the easement? The development company did standard title work. Again, not what I asked. Did they know the easement was restricted to agricultural use? I'd have to review their records to answer that definitively. Judge Morrison looked unimpressed. You're arguing against an injunction on use of this easement, but you can't tell me whether your client knowingly violated its terms. Your Honor, even if the technical language of the easement says agricultural use, decades of contrary use have established different rights. Decades. The development is 5 years old. The road has existed in various forms for much longer. On a legally restricted easement. Mr. Chen, what are you seeking here? David was ready. Your Honor, we're asking for 3 things. First, a declaratory judgment that Mr. Warner is not legally part of the Meadowbrook Hills HOA. Second, an injunction preventing the HOA from taking any enforcement action against him. And third, an injunction preventing the development from using his easement until proper access rights are negotiated. Your third request could effectively shut down access to how many homes? Approximately 75, Your Honor. There was a murmur through the courtroom. Patricia Winters looked ready to explode. That's a significant impact, Mr. Chen. Yes, Your Honor, which is why we're not requesting it lightly. But Mr. Warner's property rights have been violated repeatedly and systematically. The development built their access road on his property without permission or compensation. The HOA is trying to force him into membership without proper notification or due process. He's entitled to protect his rights. Judge Morrison sat back thinking, here's what I'm going to do. On the HOA membership issue, I'm granting a preliminary injunction preventing any enforcement action against Mr. Warner pending a full hearing on the merits. The notification issues Mr. Chen raised are substantial enough to warrant a full hearing. Gerald Hayes stood. Your Honor, I'm not finished. On the easement issue, this is more complicated. Mr. Chen, your client has a valid claim that the easement terms are being violated. However, blocking access to 75 homes is a drastic remedy with serious implications. I'm going to order mediation on this issue. Both parties will meet with a court-appointed mediator within 30 days to negotiate access rights. If mediation fails, we'll schedule a hearing on the injunction. She banged her gavel. Next case. Outside the courthouse, Patricia Winters tried to intercept me. Mr. Warner, you need to understand what you're doing. There are families in Meadowbrook Hills who did nothing wrong. You're threatening their access to their homes. I'm protecting my property rights. Your development should have checked the easement terms before building their road. This is vindictive and petty. No, Patricia, what's petty is trying to force me into your HOA so you can tell me what color to paint my fence. What's vindictive is threatening to take my property because I won't submit to your authority. I didn't start this fight, but I'm damn well going to finish it. Her face went red. We'll see about that. As she stalked off, David put a hand on my shoulder. That went better than I expected. She hates me. Good. Angry opponents make mistakes. The court-ordered mediation took place 3 weeks later in a conference room at the county courthouse. Present were myself and David, representatives from the development company including their CEO Brandon Fletcher, Patricia Winters representing the HOA, and their attorneys including Gerald Hayes. The mediator was a retired judge named Walter Simmons, who had a reputation for cracking tough cases. All right, everyone, let's start with some ground rules, Walter began. This mediation is confidential. Nothing said here can be used in court if we don't reach an agreement. The goal is to find a solution that works for everyone. Mr. Warner, why don't you start by explaining what you want? I had rehearsed this with David. I want recognition that I'm not part of the Meadowbrook Hills HOA and never will be. I want compensation for the unauthorized use of my easement for the past 5 years, and I want a formal access agreement that protects my rights going forward. Brandon Fletcher, the CEO, spoke up. He was a smooth-looking man in his 50s, the kind who probably thought he could charm his way through any problem. Mr. Warner, I think we can work something out. What kind of compensation are you looking for? Fair market value for the access rights. We've had it appraised. $25,000 per year for the past 5 years, so $125,000 in back compensation, and a formal agreement for ongoing access at market rate. Patricia made a strangled noise. That's outrageous. That's what easements cost, Patricia. You should have negotiated this before you built your road. Gerald Hayes jumped in. Mr. Warner, you need to be reasonable. You're talking about charging for access that's been free for 100 years. It was free when it was agriculture using the easement as intended. Your development is not agriculture. You changed the use without permission. That voids the easement terms. Walter held up his hand. Let's focus on solutions, not arguments. Mr. Fletcher, what's your position? Brandon exchanged glances with his attorneys. We're willing to negotiate a formal access agreement. We're not willing to pay $125,000 for what amounts to driving on a road. It's not just a road, David interjected. It's a legal right of access across private property. Those rights have value. Fine. We'll pay $20,000 for a permanent access easement. I shook my head. Not permanent. 20-year terms with renewal options, and not $20,000. Try $100,000 upfront plus $5,000 annually. Absolutely not. We went back and forth for 2 hours. Brandon and his team kept trying to lowball the numbers. Patricia kept interjecting about how unfair I was being to the innocent homeowners. Gerald Hayes made technical legal arguments that Walter shot down. Finally, Walter called for a break. During the break, David pulled me aside. They're scared, he said quietly. They don't want this going to a hearing because they know they'll lose. Push hard. When we reconvened, Walter made a proposal. Here's what I suggest as a compromise. The development pays Mr. Warner $75,000 in back compensation. They negotiate a 20-year access agreement at $4,000 per year, and Mr. Warner drops his opposition to the easement use during the term of the agreement. What about the HOA issue? I asked. That's separate. But Mr. Fletcher, if your company is willing to acknowledge that Mr. Warner's property was improperly included in the HOA boundaries, it would go a long way toward overall resolution. Brandon looked pained. If we acknowledge that, it opens the door for every other property owner to make the same claim. Maybe you shouldn't have improperly included them in the first place, I said. Patricia's voice was ice. The county approved our expansion legally. Did they? Walter asked. Because I've read the newspaper articles like everyone else. That approval is looking shadier by the day. Gerald Hayes spoke up quickly. Your Honor, we're not here to discuss the county's process. No, but it's relevant context. Mr. Fletcher, I'll be blunt. If this case goes to a full hearing, Mr. Warner is likely to win on both issues. The easement violation is clear-cut. The HOA membership is questionable at best. Your options are to negotiate a settlement now or face a court order that could be much worse for you. There was a long silence. Finally, Brandon let out a long breath. $75,000 plus the annual access fee. 20-year term with renewal option at renegotiated rates. We acknowledge Mr. Warner's property was included in the HOA boundaries in error and remove it from the district. And all other properties in similar situations, I added, absolutely not. Then no deal. I'm not settling just for myself while screwing over everyone else in the same boat. David gave me a slight smile. We had discussed this. I was not going to be the guy who got his and left everyone else hanging. Walter looked at Brandon. Mr. Fletcher, Brandon's jaw was tight. We'll review all other disputed properties on a case-by-case basis and remove any that were improperly included due to notification failures. In writing with a deadline, David said, within 60 days, 30, 45, and that's final. I looked at David. He gave a tiny nod. Deal, I said. The formal settlement agreement took another week to draft and finalize. In the end, I received $75,000 for past unauthorized use of my easement, plus a formal access agreement that would pay me $4,000 per year for 20 years, with options to renegotiate after that. My property was officially removed from the HOA boundaries, with a permanent notation in the county records that it was not subject to the Meadowbrook Hills covenants. More importantly, the development company agreed to conduct a comprehensive review of all properties that had been incorporated into the HOA boundaries and remove any where proper notification had not occurred. Within 45 days, they removed 11 properties, including Sarah Mitchell's vacation cabin, but the real victory came 2 months after our settlement. The FBI announced an investigation into corruption in county government. It turned out that County Commissioner Rick Stevens had received not just money, but also a partnership stake in a related development project in exchange for approving the Meadowbrook Hills expansion. The approval process had bypassed normal environmental and notification requirements, specifically because Stevens had pushed it through. Stevens was indicted on federal corruption charges. The county attorney who had sent me that letter suggesting I was being difficult suddenly resigned to spend more time with family. And Mountain Vista Properties, the development company, faced significant fines for their role in the scheme. Patricia Winters tried to maintain her position as HOA president, but the homeowners had had enough. At the next annual meeting, she was voted out and replaced by a more reasonable board that focused on actual community improvement rather than petty enforcement and expansion. I kept my property, my independence, and my 2 horses. The $75,000 I received went toward upgrades I had been putting off, including a new barn and solar panel installation. On a warm day in June, about 6 months after Patricia had pounded on my door during that blizzard, I was working in my garden when a car pulled up my driveway. For a moment, I tensed, wondering what new crisis was arriving. But it was just Sarah Mitchell, the woman who had helped me figure out the easement situation. She got out carrying a bottle of wine and a smile. "Thought you might like a celebration drink," she said. "What are we celebrating?" "I just got my final paperwork. I'm officially out of the HOA. No more restrictions on how I can use my own vacation cabin. And it's all thanks to you." We sat on my porch, watching the sunset over the mountains and talking about property rights, community responsibility, and the fine line between reasonable rules and authoritarian overreach. "You know what the crazy thing is," Sarah said. "I'm not against HOAs in principle. If people want to buy into a community with shared rules and standards, that's fine, but it has to be voluntary. You can't just force people into your system because you decided their property should be part of your empire." That's what Patricia never understood. It wasn't about the rules themselves. It was about the choice. You think she learned anything from all this? I thought about the last time I had seen Patricia, at the courthouse during one of the final hearings on the corruption investigation. She had looked diminished somehow, less certain of her righteousness. Maybe. Or maybe she just learned to be more careful about who she tries to push around. Sarah laughed. Either way, she's not going to forget you anytime soon. That was true enough. Lucas Warner, the guy who fought back against the HOA and won. The guy whose easement ended up exposing a whole network of corruption and illegal land grabs. The guy who refused to be pushed around. I could live with that reputation. Over the following months, life returned to normal. I worked my consulting jobs, took care of my horses, and enjoyed the solitude of my property. The access road through my easement continued to serve the development, but now I received regular payments for that use. The homeowners whose access depended on that road were not my enemies. They were just people living their lives. The development company and the HOA were the ones who had screwed up, and they were the ones who paid the price. In September, I received a letter from one of the homeowners in Meadowbrook Hills, a woman named Clara Rodriguez. She wrote to thank me for fighting the HOA's overreach. Her property had been on the edge of the development, and she had been facing thousands in special assessments for drainage improvements she neither wanted nor needed. After the corruption investigation and the leadership change, those assessments were canceled. The new board was actually working with homeowners instead of dictating to them. I wrote back telling her I appreciated the note, but that I had just been protecting my own rights. She replied saying that sometimes protecting your own rights protects everyone's rights, and that's worth celebrating. She had a point. In October, I got one final piece of news about the case. County Commissioner Rick Stevens pleaded guilty to corruption charges and was sentenced to 3 years in federal prison and ordered to pay significant fines and restitution. The county was working to reform its land use approval processes to prevent similar abuses in the future. Brandon Fletcher, the development company CEO, was not criminally charged, but faced civil penalties and permanent restrictions on his ability to do business with the county. Mountain Vista Properties was sold to a larger development firm that promised to operate with more transparency and accountability. And Patricia Winters. She moved to Arizona and was no longer my problem. On a cold day in December, almost exactly a year after that blizzard that started everything, I was in my workshop when I heard the sound of hooves. I looked out to see a group of riders on the trail that ran along my property boundary. Montana had beautiful public lands and trails, and I enjoyed seeing people out enjoying them. These riders waved as they passed, and I waved back. That's what property rights were really about, I thought. Not keeping everyone out or building walls around yourself. It was about having the freedom to use and enjoy your own land, and the right to decide for yourself what rules you wanted to follow. The HOA had tried to take that away from me, first through deception and improper procedures, then through threats and legal intimidation. They assumed I would either not notice or not care enough to fight back. They assumed their money and organization would overwhelm one individual property owner. They were wrong. I went back to my workbench, where I was building a new fence section. Not because any HOA told me to, but because I wanted to. The wood was rough and honest under my hands, the work satisfying in its simplicity. The phone rang. It was Tom Henderson, my neighbor. Lucas, just heard something interesting. Remember that county attorney who resigned? Margaret Lawrence. She just got hired as counsel for a HOA in Bozeman, I laughed. Some people never learn. Ain't that the truth? Hey, bunch of us are getting together Friday night at Murphy's Bar. You should come. I'll be there. After we hung up, I realized I was smiling. A year ago, I had been a solitary guy who mostly kept to himself, content with his property and his privacy. I still valued those things, but the fight with the HOA had connected me with people I never would have met otherwise. Sarah Mitchell had become a genuine friend. The other property owners I had worked with during the legal battle occasionally called just to chat. Even Tom, who I had known for years as just a neighbor, had become someone I actually spent time with. Fighting for your rights did not just protect your property. It connected you to your community in ways that actually mattered, ways that were based on mutual respect and shared values rather than coerced compliance with arbitrary rules. As evening fell, I fed my horses and stood for a while in the cold, looking out over my land. The mountains in the distance were purple against the darkening sky. Smoke rose from my chimney, and I could see the warm glow of lights from my house. This was mine. Not because a HOA said it was okay, not because I had complied with someone else's vision of how property should look or be used, but because I had bought it, taken care of it, and when necessary, fought for it. Patricia Winters had knocked on my door during a blizzard thinking she was going to intimidate another property owner into submission. Instead, she had awakened something she never anticipated, the stubborn determination of someone who refused to be pushed around. The easement that ran through my property was just a strip of land, a legal right recorded in old documents that no one had bothered to check. But it became leverage, and that leverage became justice, not just for me but for everyone who had been caught up in the HOA's illegal expansion. I walked back to my house, boots crunching in the snow. Inside, it was warm and comfortable, exactly how I liked it. My fence was the wrong color according to HOA standards. My outbuildings were not architecturally consistent. I had visible firewood storage, an excessive driveway, unauthorized vehicles, and non-approved house colors, plus livestock, and it was perfect. That night, I opened my laptop and started writing an account of everything that had happened, from Patricia's first knock through the settlement and aftermath. Other people were fighting similar battles across the country, and maybe my experience could help them. The specific laws varied by state, but the principles were universal. Know your rights, document everything, don't be afraid to stand up to bullies, and never underestimate the power of old records. I titled the document, How I Fought an HOA and Won, and posted it to several property rights forums and local Montana groups. Within a day, I had dozens of messages from people in similar situations asking for advice. I answered what I could and connected them with resources, including David Chen's law firm and Sarah Mitchell's property rights advocacy group. By spring, a group of Montana legislators were working on new laws to strengthen property owner notifications and limit HOA powers to expand their boundaries. The corruption case had created momentum for reform, and citizens across the state were demanding better protections. I testified at a committee hearing in Helena, explaining my experience and why better safeguards were necessary. Sitting in that government building, speaking to elected officials about property rights and due process, I felt like I was part of something larger than my own individual case. The reforms passed later that year. They were not perfect, but they made it significantly harder for HOAs to pull the kind of stunt Meadowbrook Hills had attempted. Property owners had to receive direct, certified notification of any changes to their property status. Easement terms had to be thoroughly researched and disclosed before any development could use them. And county officials faced stricter oversight and transparency requirements in land use decisions. None of that would have happened if I had just paid Patricia's $4,000 and repainted my fence. 2 years after that blizzard, I stood in my yard watching construction crews working on a new access road for Meadowbrook Hills. After all the legal drama, the development company had finally done what they should have done originally. They bought land and built a proper, legal access road that did not depend on my easement. My access agreement with them was still in effect, but now it was optional for them. They were paying me $4,000 a year for backup access, which was fine by me. The monthly checks were nice, and the arrangement was finally legal and proper. Sarah Mitchell drove up while I was watching the construction. She had become a regular visitor, and there were hints of something more than friendship developing between us, though we were taking it slow. "Looks like they're making progress," she said, standing beside me. "Should be done by fall. Does it feel weird?" After everything that happened, now they're just going about their business like normal. That's how it should be. They screwed up, they paid the price, now they're fixing it properly. That's how the system is supposed to work. You're more forgiving than I would be. I'm not forgiving Patricia Winters, but the people living in those houses, they're just people. They deserve proper access without it depending on my goodwill. This is better for everyone. She smiled and took my hand. "You're a good man, Lucas Warner." "I'm a stubborn man who refused to be pushed around. There's a difference." "I don't think there is." We walked back to my house together, past the fence that was still the wrong color, past the outbuildings that were still architecturally inconsistent, past the visible firewood and the too long driveway. My horses watched us from their pasture, their coats gleaming in the afternoon sun. This was my property on my terms, the way it always should have been. The HOA learned an expensive lesson about respecting property rights and following the law. The county reformed its processes, and I learned that sometimes standing up for yourself means standing up for everyone. As Sarah and I reached my porch, I looked back at my land one more time. 150 acres of Montana freedom, protected not by walls or rules but by rights, laws, and the determination of one guy who refused to let anyone take it from him. Patricia Winters had tried to force me into submission during a snowstorm, thinking I was just another property owner who would fold under pressure. Instead, she learned that her entire development sat on my easement, that her HOA expansion was built on corruption and illegal procedures, and that not everyone can be bullied into compliance. It was one of the better lessons I ever taught anyone. And it only cost them $75,000, political careers, and a whole lot of humiliation. I considered that money well earned.